My guest today is Tim Purcell, a personal injury attorney in Houston, Texas. The subject is parental responsibility for a child's car accident. Welcome, Tim.
Thank you.
Talk to me about this.
All right. The general rule is if your child is in a car accident, the parents are not liable. However, there are some exceptions, and the biggest one is a thing called negligent entrustment.
What does that mean?
That means if the parents owned the vehicle, that is, title was in their name, and they entrusted the vehicle to their child, and they had reason to know that that child was either an unsafe or unlicensed driver, and they still permitted the child to use the car, then they could be liable. So the question becomes, does the child have a history of speeding tickets? Does the child have a history of car accidents? Does the child have a history of perhaps drinking and getting behind the wheel? If the parents are on notice of those things, they have an obligation to take the car away. And if they don't, and the child is in an accident, then they can be liable for what's called negligent entrustment.
So that doesn't mean that if you simply ask your child to run to the store for an errand and otherwise, I mean, the child is a good driver, there's not a problem here if they were to be in an accident, correct?
If they were a good driver and they're in an accident, you're not going to be liable even if the car is in your name. One way to get around, or at least try to get around, the exposure to negligent entrustment is once the child reaches 18, the parents can put the car title in the child's name, and that will go a long way towards insulating them from a negligent entrustment claim.
All right. Thank you, Tim. We appreciate your comments.
You're welcome.